timely issues in environmental law. I'm Whit from Bracewell's Austin office, and with me today is Brittany Pemberton, who's based in Washington, D.C. This morning we're going to be talking about the Federal Risk Management Plan program, namely the final rule that was adopted by EPA in December and how those changes impact members of the regulated community who are subject to the RMP program. We're also going to discuss the pending court challenges to that final RMP rule and what impact, if any, the continued uncertainty over RMP requirements will have on your compliance efforts. If you have any questions as we go through this, please type them into the comment box on your screen. We'll get to as many of the questions as we can at the end of the webinar, and if we run out of time, we'll be sure to respond to those questions in a follow-up email. Okay, so this morning we're going to cover the recent history of the RMP rule, trying to distill that tortured path into a minute or two, and then we'll review the recent amendments to that rule, which we'll refer to as the RMP Reconsideration Rule, because it's the result of the current EPA's reconsideration of the prior administration's amendments to the RMP rule that were adopted in the very last days of the Obama administration. For purposes of this discussion, we'll divide the changes to the RMP rule into two categories. One category of changes that survived the reconsideration rule, and another category of changes that did not survive the reconsideration process. Last, and this is where Brittany's DC experience will be most helpful, we will talk about the challenges to the RMP reconsideration rule, both the timeline over which we expect that to play out and also the implications of those challenges for your compliance obligations under RMP. All right, so let's talk recent RMP rule history. As I noted up front, the RMP rule has had an impressively convoluted recent history, and this slide represents my best stab at distilling it into 8 bullets. First, going back to the very start of this larger initiative, in 2013, President Obama signed an executive order number 13650, Improving Chemical Safety and Security, directing various federal agencies to develop options for increased safety and security at chemical facilities. And this had followed a number of high-profile accidents, as well as the explosion of the fertilizer manufacturing plant in the town of West, Texas, that ultimately turned out not to be caused by an accident. And then following a few years of activity by both EPA and OSHA under OSHA's PSM rule, EPA took the lead and initiated rulemaking, which culminated in this January 2017 RMP amendment rule package that hit the Federal Register in the final days of the Obama administration. And here, notably, EPA had left OSHA behind in that OSHA was not moving lockstep with proposed changes to the PSM standard in those areas where the RMP and PSM program overlap. But we did have a presidential election in 2016, and after that election, the new administration took office, and shortly after taking office, they issued some brief administrative delays of the recent RMP amendments, and then they announced that they would reconsider those Obama-era RMP amendments and started a reconsideration proceeding. Then in June of that year, EPA moved quickly and adopted the RMP delay rule, which delayed the effective date of the 2017 RMP amendments from early 2017 to early 2019, with the stated goal of preventing those new requirements from taking effect while the new administration conducted the reconsideration proceeding. That delay rule was immediately challenged in court. Now, while the legal challenge to the RMP delay rule was pending, EPA in May of 2018 issued its proposed reconsideration rule. And in that proposal, EPA proposed to roll back the new prevention program requirements that had been adopted in 2017, and at the same time proposed largely to keep the new emergency response coordination and exercise requirements from 2017 with some changes. And we'll see that that's largely how it played out in the final rule. Now, while that proposed reconsideration rule was pending, the DC Circuit struck down the RMP delay rule, meaning that the 2017 amendments, that is the January 2017 rule, those requirements sprung into effect in late 2018. And in September of that year, EPA issued a document titled RMP Amendments Compliance Information that said just that. It said that EPA had proposed to change or undo a bunch of these 2017 requirements, but that the court struck down our rule delaying the implementation so that these requirements were now in effect. And this is really where we had this great uncertainty with the RMP program. You had these 2017 program requirements suddenly effective, while at the same time EPA was actively working to undo many of them. And, in my opinion, the fact that the RMP program is largely not delegated to states and that most of those 2017 requirements still had a future compliance date meant that there wasn't a flood of enforcement activity for non-compliance with those newly relevant requirements. But again, it certainly created a great deal of uncertainty for the regulated community. Much of that uncertainty was resolved, at least to a certain extent, last December when EPA adopted the RMP Reconsideration Rule as a final rule. Now, it was immediately challenged, and we'll get to that in a moment. But now let's talk about the RMP Consideration Rule. The 2017 amendments, as I mentioned, had made a number of changes to the program, both on the accident prevention side and on the emergency response side. And for purposes of our discussion this morning, and to focus our attention on those changes that are most relevant, I'm going to divide the 2017 changes into two buckets. One, this group that survived the December 2019 reconsideration rule and are on the books now. And second, a group of changes that were rescinded in the 2019 rule. So first, let's talk about those changes that survived and the compliance dates for those changes. The first is the requirement to conduct local emergency coordination. This is a requirement to coordinate with local emergency response organizations and to document those coordination activities. It applies to both responding and non-responding facilities, and it's an annual requirement. Now, these aren't drill or exercise requirements, but rather this is about information sharing. That's what this coordination is. Sharing, for example, the facility's emergency response plan, if you have one, to ensure that the local responders have the latest version of that response plan and also updated emergency contact information for the site, as well as any other information that's necessary for the local emergency response plan. And this is the one new requirement that is already effective. This requirement sprung back into effect in 2018, and EPA has not delayed or postponed this requirement in the RMP Reconsideration Rule. So this is the one new RMP change that you have an obligation to do this year. Now is this coordination with local emergency responders. The second new requirement is the requirement to hold a public meeting within 90 days of any RMP reportable accident. Now, in the RMP program, this term RMP reportable is used, but there really isn't a report, at least as I think of it, as far as, contacting the National Response Center like you would do under CERCLA or reporting it under EPCRA. But an event is RMP reportable if it's significant enough that it must be added to the source's 5-year accident history. And as a reminder, those events that go in your accident history are accidental releases from covered processes that result in deaths, injuries, or significant property damage on site, or any known off-site deaths, injuries, evacuations, shelter in place, property damage, or environmental damage. So those are the type of events that are considered RMP reportable. And there's now this public meeting requirement after you have an event like this, but it is limited under the rules. The 2019 rules limit this public meeting requirement to those that have any known off-site impact. So that is a tweak to this requirement that EPA made in the RMP Reconsideration Rule. So if you have an accident that is significant enough to trigger your 5-year accident history, but it has only on-site impacts, it will not trigger this requirement to hold the public meeting. But if you do have that off-site impact, injuries, evacuation, shelter in place, property damage, environmental damage, then you must hold a public meeting 90 days after that event or that accident, within 90 days of the occurrence of that accident. Another change that the 2019 amendments made was they limited the scope of information that you have to provide in that public meeting, made it narrower, really tied it to the same information that you've got to include in your 5-year accident history. So they did narrow, so this 2019 revision did both narrow the scope of events that are going to trigger this public meeting requirement and also put some limits on the types of information and categories of information that you'll need to provide during such a meeting. Now, this requirement doesn't apply now, but it will apply to your first RMP reportable accident that occurs after March 15th, 2021. So it's going to kick in about a year from now. Third significant change that has survived the reconsideration and is in the rule now are the requirement to conduct notification drills. These notification drills apply both to responding and non-responding sources that have Program 2 or Program 3 covered facilities. And the goal is to test for emergency response notification mechanisms should you have an accidental release. This is an initial and then annual requirement thereafter, and the first notification exercise under the new rule must be conducted by December of 2024. So here we're getting into these more significant exercise and drill requirements. You see on the slide, you've got a few years to get ready to do these, but they are coming. The next requirement to survive reconsideration is that requirement to conduct emergency response tabletop exercise. Now, this one applies a little more narrowly than the notification drills. Notification drills are for both non-responding and responding sources. The tabletop exercises, as well as the field exercises next, only apply to those responding sources. And there's an obligation to conduct one initially and then at least once every 3 years. And this, again, this isn't field work. This is a discussion of activities between the source and the local responders, talking about what actions would take place in the event of an accidental release. And again, this is one where this is an exercise that will actually require the involvement of those local responders. Timeline here is we've got essentially 3 years until December of 2023, 2021, or actually 4 years to develop the plan to do them. And then you must conduct your first tabletop exercise on or before December 2026. And then once you've started conducting them, it's an obligation to conduct them at least every 3 years thereafter. Last big category of new changes is the obligation to conduct field exercises. And this is a full-blown emergency response exercise out in the plant, testing various elements of both your notification and your internal and external response. And like the tabletop exercise, you've got sort of a two-tiered deadline here. First, by the end of December 2023, you've got to develop your plan to conduct this exercise in conjunction with the local responders. But then this is a change that EPA made in the reconsideration rule. They didn't set any specific deadline for conducting the first one of these exercises, nor did they set a deadline for how frequently you have to redo them. I think the original, or the 2017 rule, had put it that they need to be conducted at least every 10 years, but now there is no minimum frequency, basically directing companies to conduct with the local responders in order to set a frequency. And one thing to think about here, especially with these exercises that are going to, you've got this obligation, this first one coming up. I know it's a long time from now, the end of 2023, but one of the reasons why the agency, why EPA reduced the burdens schedule-wise for conducting these exercises was for concerns about the local responders' bandwidth, essentially, and ability to participate in these exercises. And so I do think that there, I imagine as these deadlines approach, they will be getting contacted by folks, looking to set these up. And I imagine the earlier you coordinate them, even if it's not going to happen for a long time, you may have more control in getting it set on a schedule that works for your internal plans. So that to me is just one consideration as far as procrastination may not pay off, given that I think one of the big concerns in getting these things planned and conducted is the ability and the bandwidth of local response organizations. So those are the changes that remain on the books now. This one that applies now, one that kicks in next year, and these notification and exercise drills that you will have to comply with in the coming years. My next slide, and I'm going to go through this one more quickly, is these are changes that did not survive the reconsideration process. That is, these were all changes that were in the January 2017 rule that EPA in the December 2019 reconsideration rule has rescinded or rolled back. This list, one that frankly to me didn't get as much play in the trade press, and so the time I spend I'll be on this one, didn't get as much play as I thought it really merited. This first bullet about the scope of RMP audits. One of the things that the 2017 changes, you conduct these audits every 3 years, and one of the some ways subtle changes you saw in the 2017 rule is they said that the audit was to cover each covered process. And at least in my experience and our experience working with people, especially larger sites that have many covered processes at a large chemical plant or refinery, those every 3-year audits aren't looking at every single covered process on the site. You're picking a few that will be representative of whether you're implementing the program elements correctly across the board, but it's really you're using sort of representative sampling to do this auditing. And that 2017 rule, absent this change, would, in my view, have greatly expanded the scope of your RM auditing obligation. But again, that is no longer a requirement. That language was struck. The other requirements that did not survive, that the requirement they'd added to conduct third-party audits after you've had a 5-year accident history event or when determined necessary by an agency. This enhancement or change to the PHA process where you had to conduct a safer technologies and alternatives analysis. Changes to the incident investigation requirements, where clarifying that you would have to do an incident investigation after a near miss, and also an explicit requirement, which I didn't think was going to be a big deal to most folks, but an explicit requirement that your incident investigation had to include a root cause analysis. And last, and one that caused a lot of anxiety, there were some very broad information sharing requirements, both for the public and for local responders that were in the 2017 rule, and EPA largely eliminated those information sharing requirements in the reconsideration rule. But that is not the end of the story, and we've got more exciting RMP litigation to discuss, and that is why I'm going to hand it off to Brittany, and she's now going to talk about the legal challenges to the RMP Reconsideration Rule.
Thanks, Whit. So litigation is normally one of the biggest possible drivers of uncertainty when it comes to regulation. But as I'm going to explain as I unpack all of this morning, there might be some reasons to think that we won't see that as the case with the RMP Reconsideration Rule, at least right off the bat. There have been 5 lawsuits that have been filed. The lead case you'll see on the slides there is the Air Alliance Houston case. That encompasses about a dozen other environmental advocacy groups like the Clean Air Council and the Sierra Club. And that case has been consolidated with the 4 other cases that were filed, one by a collection of labor unions, and then a couple of cases that feature a number of states, the District of Columbia, the city of Philadelphia, and then Harris County, Texas as well is involved. In large part, these are the same petitioners who challenged the 2017 delay rule that the Obama administration, or rather that the Trump administration put out to try to extend the compliance deadlines for a number of the items that Whit just covered. That case, as you heard, was struck down by the DC Circuit in August of 2018. So I think that these folks are eager to try their luck again before the DC Circuit. There's a number of industry trade groups representing chemical manufacturers, refining interests, and the oil and gas industry that have intervened in the case in order to support EPA and its decision making. We're very early on in these cases, but the parties are going to file issue statements in the next week or week after, and that will give us an idea of exactly what it is that they're targeting from the reconsideration rule. But I think there are a couple of things that we can generally anticipate. One of those is that they'll attack EPA's rationale for reversing its position on the necessity of some of those provisions that Whit just explained didn't make it on the other side of the reconsideration rule. Of course, we know agencies can and often do change their minds, particularly when there's a change in administration. But the Supreme Court has a couple of precedents that would apply to this case, and that require EPA to show 3 things. First, they will have to, in order to defend the rule, explain that these changes are permissible under the statute. They'll also have to have a good reason for making the changes, and they just have to explain that EPA believes that the changed policies are better than the previous policies. It doesn't matter ultimately what the court thinks, whether the court thinks or the panel that you draw actually thinks that these changes are better. As long as EPA can reasonably explain the changes, it should be fairly easy for EPA to come out the other side of that argument as the victor. But even if they don't, it's unlikely that the DC Circuit would vacate the rule as a result of those arguments, but instead would probably just remand it to better explain why it has decided to change its policies. The other bucket of issues I would expect to come up in the litigation are challenges to whether and to what extent EPA can consider costs in rolling back the 2017 amendments, and challenges to EPA's rationale that doing so is necessary because the benefits of those amendments far outweigh the costs. If you've taken a dive into the record or into the preamble to the rule, EPA really tried to indicate that they think that compliance overall with RMP and the number of incidents has gone down year over year, and that most facilities are in compliance, and they just did not think that the burden of the additional regulations that were passed by the Obama administration really outweighed the potential costs of those. This is actually going to be somewhat of a statutory interpretation issue in sheep's clothes, perhaps, as it's going to probably come down to how the panel looks at EPA's authority. Under the statute, they have to develop reasonable regulations and appropriate guidance. And it's those sort of loose terms that Congress gave them that probably give them cover to look at costs. There's Supreme Court precedent on this well, particularly Michigan v. EPA, where, involving the MATS rule, where reasonable regulation generally involves some sort of examination of the benefits and the burdens of the rule. EPA probably will be in good stead to uphold this part of its rationale as well. Normally, we would expect a decision on this case probably sometime in the first part of 2021. As I said, they're just doing the issue statements now. That normally means briefing would follow in the next couple of months and probably run through the summer. Oral argument would likely to be held in the fall, and then a decision, can take anywhere from 3 months to a year, but more like 3 or 6 months probably. However, Whit, if you'll flip to the next slide, the big thing that we need to discuss is the fact that there's the potential out there for reconsideration of the reconsideration rule. There have been 3 petitions for reconsideration filed with the agency, and this is probably the greatest source of uncertainty about the path forward for the rule and for the litigation. The petitions were filed by all, if not all, of the petitioners before the D.C. Circuit. So it's pretty clear that they have what they believe to be, a number of arguments and pieces of data that were not considered by EPA during the course of the regular rulemaking that they believe should require a different outcome, and they've gone straight to the agency to try to secure that. The rub is that when you file such a reconsideration petition, any of those issues that are being raised for the first time in the petitions for reconsideration are not ripe for judicial review, and that's a feature of the Clean Air Act, as you can see from the statutory language that I've quoted on the screen, and something that the D.C. Circuit has squarely addressed in its case law in recent years. So that typically means that when a reconsideration petition is filed, the lawsuit will be placed on hold in order to give EPA time to consider whether to grant reconsideration and then maybe to go about doing so if it does grant it. And the tricky part there is that there's no timeline for EPA to respond to the petitions or to conduct any kind of rulemaking if it grants them. So once you file these things, you sort of lob them off into the universe, and it could take, potentially months or years for EPA to act at all if it decides to do so. In this case, because the reconsideration petitions are largely based on information that wasn't available to the agency before the comment period closed in August 2018, I suspect that what we'll be seeing is a request to put these cases on hold. The type of information, that the petitioners have brought to EPA's attention are a number of recent facility incidents that they claim show that the RMP program isn't working. There's an April 2019 report by the Chemical Safety Board that's addressing hydrogen fluoride in the refinery context, an EPA Office of Inspector General report from December of 2019 that looks at improvements to facility emergency planning that might be needed in light of increased frequency and severity of natural disasters. And then they also take to task some of EPA's legal conclusions in the final rule, claiming that those were new and not something that they had a chance to comment on in the rulemaking when the docket closed in August, or that they're based on data that EPA didn't include in the docket. So we'll start to see how this is going to shake out over the next couple of weeks as we see the issue statements. If there is any daylight between the issues being brought in the litigation directly and those that are in the petitions for reconsideration, there's a possibility that you could see some of the issues that have been fairly raised in the comment period before EPA severed so that those cases can go forward in the litigation while the rest is put on hold. But I think that that's pretty unlikely based on how broad the petitions for reconsideration are. The other big point that I wanted to make is that the petitions for reconsideration do ask EPA to stay the rule pending reconsideration, but based on the D.C. Circuit's 2018 opinion in the Airlines Houston case on the 2017 delay rule of the RMP regulations, we know that that stay, even if EPA is to grant it, is likely limited to just 90 days. That is probably not going to have a big impact on anyone. I think it's unlikely that EPA would stay it, and even if they do, as Whit just showed you, there are a number of compliance deadlines that are far off into the future, and a 90-day stay is just not going to have much of an impact and not going to cause a lot of the Obama rule to come springing back and create a lot of chaos for facilities. There is a chance also that the petitioners could ask the court to stay the rule pending appeal, but that's a pretty heavy burden for them to carry, and they have to ask EPA first. So we'll wait to see how that shakes out at the agency, and we may see some motions before the court in order to ask for a stay pending appeal in the next few weeks as well.
All right. Well, thank you very much, Brittany, and thank all of you for joining us this morning. I know we're bumping right up against 9 o'clock. So we don't have a chance to hit any questions that you may have sent in, but if you sent them in, we will be sure to get back with you. And again, thank you for joining us for our Environmental Essentials series this month. We'll talk to you next month.